Now, Attorney General Pam Bondi has finally released the Epstein list, a collection of 300 politicians and prominent people who were named in the files, telling Congress that all the documents the Department of Justice was required to reveal have now been made public. Kinsey, are there big names that are going to be worried about this release?
I mean, I think we had this conversation last week where Joe Rogan was like, look, I'm on the list and because I refused to meet with him. And that's what we're seeing, a lot of pushback.
All right, so Pam Bondi faced serious questioning in Congress. And I mean serious questioning. She walked into a hearing claiming she had released all the Epstein files, everything the DOJ has, nothing being hidden. And then a Republican lawmaker, someone who is also a former prosecutor and who is supposed to be on her side, stood up with documented evidence and challenged that claim directly.
You closed the case on Epstein's abusers. The July 2025 memo from your Department of Justice stated, quote, "We did not uncover evidence that could predicate an investigation against uncharged third parties." These two photos, please put the photos back up. These two photos staring you in the face are evidence of a crime and more than enough evidence to predicate an investigation against former Prince Andrew.
He pulled out a list of specific documents that Bondi never released: internal memos, draft indictments, DOJ emails, materials that the law explicitly requires her to turn over. And Bondi had no clear answer. She sat there as her defense was challenged on live television.
We've released more than 3 million pages, including 180,000 images, all to the public, while doing our very best in the time frame allotted by the legislation to protect victims. And if you brought us a victim's name that was inadvertently released, we immediately redacted it. All members of Congress, as you know, are invited to visit DOJ to see for yourselves.
This is significant because Bondi has been stating for weeks that she released everything and that there is full transparency. But now a member of her own party is challenging that claim publicly. Here is what happened. Bondi sent Congress a letter on February 14th claiming that all Epstein files the DOJ holds under the Transparency Act have been released. She included a list of about 340 names that appear in the documents, and she essentially said, "We are done, there is nothing else, stop asking." But Congress was not satisfied because the files Bondi released were heavily redacted, with large sections blacked out and key names missing.
No one at the Department of Justice interviewed this witness. You need to interview this witness immediately. Epstein should rot in hell, so should the men who patronized his operation. And as we say here today, there are over 1,000 sex trafficking victims, and you have not held a single man accountable. Shame on you. If you had any decency, you would resign right after this hearing concludes.
Lawmakers from both parties kept saying this does not look like everything, this looks like materials are still being withheld, and Bondi kept insisting that everything required by law had been released. That claim was then directly challenged. At a follow-up hearing, a Republican lawmaker who is also a former prosecutor came prepared. He had internal DOJ inventories, oversight correspondence, and specific citations to documents that Bondi had not turned over.
Here is a witness statement who called into the FBI's Threat Operations Center. He drove Donald Trump around in a limo. He overheard what Donald Trump said to Jeffrey on his cell phone. He was so angry, he was going to stop a limo and hurt Donald Trump. And he met a girl who said she was raped by Donald Trump and Jeffrey Epstein. She later had her head blown off, and officers at the scene said that could not have been suicide.
And he went through them one by one in front of Congress and the cameras. An 86-page prosecution memo from the Southern District of New York, a draft indictment from Florida targeting Epstein co-conspirators, internal DOJ emails discussing why certain people were not charged, all of it specifically referenced in prior litigation and internal records. All of it required under the Epstein Files Transparency Act, and none of it released by Bondi's DOJ. The lawmaker did not just claim these documents exist, he cited the specific case files where they are mentioned. He referenced the internal inventories that list them. He showed that the DOJ knew about these documents, cataloged them, and did not include them in the public release.
Donald Trump attended various parties with Jeffrey Epstein. I want to know, were there any underage girls at that party or at any party that Trump attended with Jeffrey Epstein?
This is so ridiculous, and that they are trying to deflect from all the great things Donald Trump has done. There is no evidence that Donald Trump has committed a crime. Everyone knows that. This has been the most transparent presidency. He's the one that asked that those files...
I'm reclaiming my time.
So Bondi cannot claim she did not know they existed. She cannot claim they are not relevant. She is now in the position of explaining why she told Congress everything had been released when specific required documents were not included. And this was not a Democrat trying to score political points. This was a Republican, someone who should be aligned with Bondi. But he brought the documentation and raised these concerns publicly. Bondi tried to claim that some documents are protected by deliberative process privilege, a legal doctrine that protects internal government discussions.
You published their names, their phone numbers, their addresses, personally identifying information. If Donald Trump can get $10 billion theoretically from the Department of Justice, how much should these people get for a far worse violation of their privacy rights and a far greater danger established to them in their lives?
But the problem with that defense is the Transparency Act specifically addresses those protections for Epstein files. The law requires the release of internal memos and emails explaining why prosecutors did or did not charge people. That is written into the statute, so Bondi cannot rely on deliberative process as a blanket protection. The law addresses that directly, and her continued use of it as a justification is being challenged by legal experts on both sides. This development significantly complicates Bondi's position. For weeks, she has been telling Congress and the public that everything has been released, that there is full transparency, and that anyone pushing for more is being political. But now, there are specific documents identified that she did not release. There is evidence that the DOJ knew these documents existed and did not include them. And there is a member of her own party raising these concerns publicly. The contempt case against Bondi has become stronger as a result. Before this hearing, there was a general argument that compliance was complicated, but now Congress can point to concrete examples of specific documents that were described as released but were not. That moves the conversation from a disagreement about compliance to a more serious question about whether Congress was misled. And the implications are significant because if these specific documents were withheld, the question becomes what else may not have been released? What other files could still be outstanding? Are there more memos, more emails, more draft indictments? How many names are still being redacted? The documents Bondi is withholding apparently explain why certain Epstein associates were not charged. That means there are people who prosecutors considered charging and then did not. And Bondi is sitting on the memos that explain who those people are and why they were not prosecuted. Were they protected because of wealth, political connections, or relationships with people in power? The draft indictment and prosecution memos could answer those questions, and Bondi has not released them. So now she is facing increased pressure. The contempt proceedings that were already moving forward have received new momentum because Congress can now point to specific documents that were not included in what Bondi described as a complete release. They can argue that her continued refusal to turn over these documents is willful obstruction. And because a Republican prosecutor raised these concerns, Bondi does not have the defense that this is purely partisan. Her own side has questioned her publicly, and that makes the situation significantly more serious. Let's look more closely at exactly what documents have been identified as missing and why this matters. The Epstein Files Transparency Act was not just about releasing investigative files like police reports and witness statements. It specifically required the DOJ to release internal documents explaining prosecutorial decisions, why certain people were investigated, why some were charged and others were not, what evidence prosecutors had, and what legal theories they considered. All of that was required to be made public under the law, and that is the material that has not been fully released. The first major document identified as missing is an 86-page prosecution memo from the Southern District of New York. This is a detailed internal document that prosecutors wrote analyzing the Epstein case and making recommendations about who should be charged. These memos are important because they lay out the evidence prosecutors had, the potential charges they considered, and the reasons for their decisions. In Epstein cases, those memos would identify other people involved, co-conspirators, enablers, and potentially others connected to his operation. And this memo is confirmed to exist because it is referenced in court filings from Epstein-related civil cases. Lawyers representing victims cited it. Judges acknowledged it. It is part of the official record. So Bondi cannot claim it does not exist. The memo is real, the DOJ has it, and it was not included in the public release. The second major missing document is a draft indictment from Florida targeting Epstein co-conspirators. This is also confirmed to exist through court references and internal DOJ records. A draft indictment means prosecutors got far enough in their investigation to actually write up formal charges against specific people. They identified co-conspirators by name. They laid out the criminal conduct. They prepared to go to a grand jury, but the indictment was never filed. The draft indictment would identify who those co-conspirators were and what they were going to be charged with. And if prosecutors were ready to charge Epstein associates and then did not proceed, the public deserves to know who those people are and why they were not prosecuted. The draft indictment would help answer those questions, and it has not been released. The third category of missing documents is internal DOJ emails discussing prosecutorial decisions. According to the Republican lawmaker who raised these concerns, there are extensive email chains between DOJ officials, FBI agents, and prosecutors discussing the Epstein investigation and related cases. These emails would show the internal discussions about who to charge, what evidence was available, what obstacles existed, and potentially what considerations were involved in decisions not to charge certain people. This is exactly the kind of transparency the Transparency Act was designed to require. But Bondi has been citing deliberative process privilege to keep these emails from being released. And as noted, the Transparency Act specifically addresses that privilege for Epstein files, requiring release even of materials that would normally be protected. Now let's address the redactions because that is another significant concern. The files Bondi did release are heavily redacted, large sections are blacked out, and key details are missing. When Congress asked why so much was redacted, Bondi said it was to protect victim privacy and ongoing investigations. But legal experts say that does not justify the extent of the redactions. Victim names can be redacted, that is legitimate. But the names of associates and others connected to Epstein's operation should be subject to the transparency requirements. Al Jazeera reported that at least 6 prominent names were redacted from documents that members of Congress later read into the public record. So these are names of people connected to Epstein's operation, people who were involved or knew what was happening, and those names are being withheld. The political fallout from this is serious because Bondi is not just facing pressure from Democrats. She has Republicans calling her out publicly. The prosecutor who raised these concerns is a conservative. He is someone who would normally be defending her position. But he brought documentation and raised these questions publicly, and that tells you how significant the concerns are. This completely changes the contempt proceedings. Before, Bondi could argue that compliance was complicated and she was doing her best in good faith. But now, Congress has specific examples of documents she said were not required or did not exist that actually do exist and are required by law. That is not a good faith disagreement about the law. That is a much more serious problem, and it makes the case for accountability considerably stronger. The calls for stronger action are also growing because misleading Congress in testimony is serious. If Bondi told Congress everything had been released when specific required documents were withheld, that raises significant legal and ethical questions. And if she continues to refuse to release these documents even after being publicly challenged, that strengthens the argument for the harshest available responses. The bottom line is this: Bondi's claim that everything has been released has been directly and specifically challenged. A Republican prosecutor identified documents by name that were not released and are required under the law. And now she is facing consequences that could include fines, contempt proceedings, and calls for impeachment. The files she is withholding apparently explain why certain Epstein associates were not charged, who they are, what evidence existed against them, and who made the decision not to prosecute. That is exactly what the public and Congress demanded transparency about. And the pressure on Bondi to comply is now coming from both sides of the aisle,